I'm John Mitchell, and I want to talk briefly about filing for bankruptcy with a non-attorney. First of all, there's no specific requirement that anyone file bankruptcy with an attorney, although in many cases it's usually advisable based upon the issues and the complications that may be involved. But one of the things I want to address is non-attorney petition preparers. Now, a lot of times advertisements will be run in newspapers and other classifieds indicating, the $200 bankruptcy, the $150 bankruptcy. These are typically going to be non-attorneys, specifically petition preparers, and that may or may not be a paralegal. There's no specific requirement on that. And in most cases, there are certain limitations as to what a non-attorney petition preparer can do for you. Now, first of all, since they're not attorneys, they're not going to be able to give you any kind of legal advice. Basically, what they will do is take the information you provide them and put it into a bankruptcy petition and then file that with the court. As a non-attorney, they're not allowed to give you any type of advice regarding exemptions and other matters like that that may come up in a bankruptcy. They're also not allowed to represent anyone in court, obviously, if you're not an attorney. And that's important because every bankruptcy has at least a 341 or meeting of creditors attached to it. So if you file for a 7 or a 13, you're required to attend a meeting of creditors. Now, a bankruptcy petition preparer, as a non-attorney, will not be able to represent you at this hearing. So basically, you'll be doing it on your own. And that may or may not be something that would be advisable. So basically, the breakdown is that with an attorney, you can get full representation. With a petition preparer, you're basically getting someone who can transcribe information and put it into a form. Now, one of the major issues to consider is what happens after you file for the bankruptcy and after the 341 meeting. It is possible that there could be adversarials or some sort of issue come up with the bankruptcy that would require an appearance in court or several. And if you have filed through a petition preparer, you're basically representing yourself. And going into court may or may not be something that you particularly want to do, may not be advisable, depending upon the issues that are involved. And at that time, if you wanted to hire an attorney, after having filed already, the costs would usually be increased or at least more complex. So overall, the decision is whether or not to hire an attorney or not. There's some basic limitations to what a non-attorney can do for you. But if you have a complicated case or if you have issues that you don't necessarily want to have to deal with on your own, then it's usually at least worth getting a consultation with a qualified bankruptcy attorney.